Hello friends, welcome to Prashant IAS. So friends, before starting today's lecture, I would like to tell you something. So friends, when I taught you about procedure established by law and due process of law, in that class I asked one question. And the question was that what are they? Means what is procedure established by law and what is due process of law. So my question was that what are they? But friends, I am really disappointed that very few students gave the answer. Okay, and actually I don't care whether the answer is correct or answer is wrong, because actually you are here because you want to learn, you don't know. Okay, so I don't care whether the answer is correct or answer is wrong. But actually, at least you all should try to give the answer. Okay, so I actually praise all those students who gave the answer. No matter whether their answer was correct or it was not correct, but at least they gave the answer. So I request you all that next time whenever I ask any question, then you all should try to give the answer. Okay, and please don't hesitate to answer. Even if your answer is not correct, then also you will get a chance to learn something. Okay, because actually you are here because you don't know. So don't hesitate to answer. Give your answer. So friends, now I will tell you that actually what are they, means what is procedure established by law and what is due process of law. So friends, they are actually the procedure methods of judicial review. Okay, so procedure established by law and due process of law are methods of judicial review. Means whenever judiciary reviews the action of executive, then judiciary uses procedure established by law. And whenever judiciary reviews the action of legislature or executive, then judiciary uses due process of law. So procedure established by law and due process of law are the methods of judicial review. Now friends, there is one more assignment for you all. So friends, in the last class, I taught you about Article 22 Clause 2 and Article 22 Clause 3. And there I deliberately did a little mistake. Okay, and now your assignment is to find out that what is the mistake. Okay, so I deliberately did a little mistake in Article 22 Clause 2 and Article 22 Clause 3. So you have to look the slide in which I taught you about Article 22 Clause 2 and Article 22 Clause 3. And in that slide only there is a little mistake. And your assignment is to find out that what is the mistake. And friends, I will announce the name of all those students who will give the correct answer. Okay, and I will announce the name of all those students in the next class. So now it is your duty to find out the mistake in Article 22 Clause 2 and Article 22 Clause 3. And I will announce the name of all those students who will give the correct answer. And at least you all should try to give the answer. Please don't worry your answer is correct or your answer is wrong. And friends, please try to give me answers on my Instagram. Okay, please don't use comment section to give the answer. You can message me on Instagram to give your answer. Okay, and I will announce the name of all those students who will give the correct answer. Okay, and please message me on Instagram. Okay, and don't use comment section to give your answers. To give your answer, you should message me on Instagram. So friends, in the last class, we have completed our discussion till Article 27 of the Indian Constitution. And from this class, we will continue our discussion with Article 28 of the Indian Constitution. So friends, what is Article 28? So Article 28 actually categorizes the educational institutions into 4 categories. Okay, so Article 28 categorizes the educational institutions. Educational institutions means schools and colleges into 4 categories. So first of all, we will try to understand that what are those 4 categories. So friends, the first category or A is educational institutes which are completely owned and managed by the government. Okay, now what does it mean? It means all the educational institutes, means all the schools and colleges which are owned by the government and which are managed by the government. Means who is the owner of these educational institutions? So definitely government is the owner of these educational institutions. And who manages these educational institutions? So government manages these educational institutions. So in first categories, all those schools and colleges comes which are completely owned by the government, means their ownership is in the hands of government, they are owned by the government, and moreover they are also managed by the government. So for example, all the government owned schools and colleges will come under this category. Okay, so all the government owned schools and colleges will come under this category. So in first category, all the schools and colleges means all the educational institutions which are completely owned by the government and which are completely managed by the government. Now let's move to second category. So what is second category? So friends, second category or B is educational institutes which are privately owned but aided and recognized by the state. Now what does it mean? So it means that all the schools and colleges, means all the educational institutions which are owned by any private individual, means government does not have the ownership of these educational institutions. Okay, so who is the owner of these educational institutions? So any private individual, any private person is the owner of these educational institutions. So the first point is that these educational institutions are not owned by the government, means government is not their owner. So who is their owner? So any private individual is their owner. Now second point is that these institutions are aided by the government. They are aided and recognized by the government. Now what does it mean? So aided means government gives them financial help, means government gives them money, governments give them monetary help. Okay, so these educational institutions receive monetary or financial help from the government. Okay, and definitely all the educational institutions are recognized by the government only. Okay, so these educational institutions are also recognized by the government. So in second category, all those schools and colleges will come which are actually not owned by the government, but government gives financial help to these educational institutions, and moreover they are recognized by the government. Now let's see what is the third category. So friends, in third category, educational institutes which are privately owned and unaided, though recognized by the state. Now what does it mean? So first point is that these educational institutions are not owned by the government, means again their owner is any private individual. These educational institutions are not under the ownership of government. Any other private individual has the ownership of these educational institutions. Now friends, the second point is that these educational institutions are unaided by the government. Unaided means government does not provide any financial help for the management, for the working of these educational institutions. Okay, so government does not provide any financial help, any monetary help for the working, for the management, or for any kind of thing to these educational institutions. But they are also recognized by the government. They are also recognized by the state. So in third categories, these type of educational institutions will come. Now what is fourth category? So in fourth category comes educational institutes which are managed by the state but founded by the fund in the form of religious endowment or charity. Now what does it mean? So let me explain you this with the help of an example. So suppose there is any particular religion, okay, and there is an educational institute, and that suppose there is a college, and that particular college is made by the money which is received in the form of religious endowment or charity. So first of all, question arises that what is this religious endowment or charity? So it means religious donation, means donation for religion, gift for God. Okay, so when people gives donation to temples, to their religion, then it is known as religious endowment or charity. So religious endowment or charity means a kind of donation for religion. Now these educational institutions are established by using the money of this donation, means no private individual provides money for the establishment of these educational institutions. Moreover, government does not provide money for the establishment of these educational institutions. Okay, so from where does money come? So money comes from the religious endowment or charity, means which religion has through donation. Okay, so suppose if there is any particular religion and the followers of that religion donated money, okay, to their religious institute for their religion. Okay, and the money which is collected by donation, which is collected by charity, now this money will be used, means the money which is collected by religious donations, which is collected by charity, now this money will be used for the establishment of this educational institute. Okay, so the first point is clear. So what is first point? So first point is that these type of educational institutions are not made by the money of government or any private individual. Okay, so from where does money come? So definitely these kind of educational institutions are made by the money which comes from the religious donation, religious charity. Okay, now friends, but these educational institutions are managed by the government. Okay, so the second point is that this fourth category of educational institutions are managed by the government. So friends, now I hope that you all are clear with the meaning of these all four categories of educational institutions. So let's move further. Now friends, let's see what actually Article 28 says. What actually Article 28 does. So Article 28 deals with imparting religious teaching in educational institutions. Okay, so Article 28 actually deals with imparting the religious teachings in the educational institutions. Now what does it mean? So it means that Article 28 tells us that whether religious teachings can be given in which category of educational institutions or not. Okay, so Article 28 tells us that whether the religious teachings can be given in educational institutions or not. And if religious teachings can be given, then in which category of educational institutions can give these type of teachings. Okay, so what is the basic work of Article 28? So Article 28 deals with giving of religious teachings, means teachings related to religion, okay, in the educational institutions. Now friends, it divides educational institutions into four categories. So I have told you that what are these four categories and I have explained you it in detail. So now let's move further. Now friends, in the first category, no religious teachings whatsoever can be imparted. Okay, so what is first category? So in first categories, all the educational institutions which are completely owned and managed by the government comes. Okay, so what is first category? So all the government educational institutions, means all the educational institutions which are actually owned by the government and they are managed by the government. These are educational institutions will come. So in these type of educational institutions, no religious teachings can be given. No religious instructions can be given. For example, in any government owned educational institute, you cannot teach the students about Hindu religion. You cannot teach them about Islam religion, Christianity, Buddhism, Jainism or any religion. Okay, so in first category of educational institutions means educational institutions which are actually government owned and managed by the government. In these kinds of educational institutions, no religious instructions can be given. Okay, now in second and third category, religious instructions can be imparted but students cannot be compelled to attend them. Now what is second and third category? So second and third category were the private educational institutions, means the educational institutions which are privately owned. Now what was the difference? So in second categories, these educational institutions were aided by the government, and in third category, these educational institutions were unaided by the government. So whether any educational institution which is actually privately owned, so whether these kind of educational institutions are aided by the government or they are unaided by the government, religious instructions can be given in these educational institutions. But there is a condition. The condition is that you cannot force the students to attend the religious teachings. Okay, so religious teachings can be given in privately owned educational institutions, but actually teachers and authorities and actually no one can force the students to attend those teachings, to attend those religious teachings. Okay, so it is the choice of the student. So if a student want to attend, then a student can attend, and if a student do not want to attend, then nobody can force the students. Now friends, in fourth category means educational institutions which are managed by the state but founded by the fund in the form of religious endowment or charity. So in this category, religious instructions can be imparted, means religious teaching can be done. And friends, students can also be compelled to attend, means authorities can force the students to attend the religious teachings. Okay, so if any student doesn't want to attend the religious teaching, then teachers can force him that you are actually studying in an educational institute which are established out of the donation money. Okay, which are established out of the money which the followers of this particular religion gave. So now you are supposed to attend the religious teaching. So in fourth category, students can be forced to attend these teachings, to attend these instructions. So friends, now let's move further. So friends, then comes Article 29. So what Article 29 says? So Article 29 is protection of the interest of minorities. Okay. Now friends, though the title of Article 29 is protection of the interest of minorities, but the actual language of Article 29 Clause 1 extends this right to all the sections of citizens who are the resident of India. Now what does it mean? So it means that when you will read the title of Article 29, so what is the title of Article 29? So Article 29, the title of Article 29 says that the protection of interest of minorities. Means according to the title, means when you will study the title, then you will think that Article 29 wants to only protect the people belonging to minority communities. Article 29 only wants to protect the interest of people who belong to minority community. So when you will read the title, then you will think that actually Article 29 want to do this. But that's not the case. The case is different. So first of all, the question arises that what is minority? So friends, I will try to explain you the meaning of minority in very simple terms with the help of an example. So minority means if people belonging to one specific group are less in number than the other groups. Okay. So if people belonging to one specific group are less in number than the other groups, then that particular group will be known as minority. So I will give you one example so that you can understand this concept very easily. Suppose friends, there is a state, okay, and in that state there are 100 Hindus. Okay, so 100 Hindus are living, 10 Muslims are living, 5 Christians are living, and 2 Buddhists are living. Okay, so what is the composition of the state? That in that state 100 Hindus are living, 10 Muslims are living, 5 Christians are living, and 2 Buddhists are living. So now we can say that definitely the population of Hindus is more than all the other communities. So we can say that Hindu is in majority. Why? Because the number of Hindus is more than the number of the people of any other community. So Hindus are in majority. But definitely Muslims are less in number, Christians are less in number, and Buddhists are also less in number. Their population is 10, 5 and 2 respectively. So now we can say that Muslim, Christians and Buddhists are minority. Okay. So now I hope that you are very clear with the meaning of term minority. So friends, if you will read the Article 29's title, so when you will read the title of Article 29, then you can think that this article only provides protection for the interest of minorities. But when you read Article 29 Clause 1, when you will read the actual language of Article 29 Clause 1, then you will jump to the conclusion that it actually provides protection to all the groups of citizens who are living in India, to all the sections of citizens who are residents of India. So what is Article 29 Clause 1? So let's study it. So under Article 29 Clause 1, any section of Indian citizens residing in India having a distinct language, script or culture shall have the right to conserve it. Now what is the meaning of section of Indian citizen? It means group of Indian citizens. It can be a linguistic group, it can be a religious group. For example, Hindu is also a section of Indian citizens. Islam is also a section of Indian citizens. Similarly, Tamil speaking people, Hindi speaking people. Okay, so it denotes a group of people, group of Indian citizens, and these people has to be Indian citizens. So Article 29 Clause 1 says that any group of Indian citizens, okay, and they are the residents of India, and if that group has any different language, any different script and culture, okay, so if that particular group of Indian citizens have any different language or different script or different culture, then they will have the right to conserve it. They will have the right to conserve their language. They will have the right to conserve their script, and they will have the right to conserve their culture. For example, friends, I will give you one example so that you can understand it very clearly. Suppose, friends, we all know that Uttar Pradesh is a Hindi speaking state, and the people who speak Hindi are in majority in Uttar Pradesh. Now suppose what happens that there are suppose 500 people who speak Tamil, and these 500 people lives in Uttar Pradesh. So these 500 peoples live in Uttar Pradesh and they speak Tamil. Means their language is different from the language of majority community in UP. So now these citizens will have the right to conserve their language. They will have the right to conserve Tamil. Okay, so in further articles we will see how they will conserve it. Now what is Article 29 Clause 2? So Article 29 Clause 2 says that no citizens shall be denied admission in any educational institution maintained or aided by state only on the grounds of religion, race, caste or language. Now what does it mean? So it means that if any educational institution, whether it is a college or a school, if that educational institution is maintained or aided by the state, okay, if that educational institution is maintained or aided by the state means that educational institution is maintained by the money which state gives, which government gives. Or in other words, we can say that if government gives money for the management, for the maintenance of that educational institute. So in these type of educational institutions, no authority or government can deny any citizen to take admission only on the grounds of religion, race, caste or language. Means no citizen can be denied admission in any educational institution which is maintained or aided by the state only on the grounds of religion, race, caste or language. So let me give you one example so that you can understand it more clearly. So suppose, friends, there are two persons. The name of first person is Santa and the name of second person is Banta. Now suppose, friends, this Santa belongs to a upper caste Hindu and this Banta belongs to a lower caste Hindu. Now suppose there is a college and that college is aided by the government. Means government gives money for the maintenance of that college. Now the authorities of college or government cannot say that because Santa belongs to upper caste, I am giving admission to Santa. But Banta belongs to lower caste, I am not giving admission to Banta. So they cannot say like this. Means they cannot deny admission. They cannot discriminate between citizens in giving admission in educational institutions which are aided by the state only on the ground of caste. Similarly, these concepts will also be similar for religion, race and language. Okay, so let's move further. So friends, then comes Article 30. So what Article 30 says? So Article 30 deals with right of minority communities to establish and administer educational institutions. So friends, Article 30 actually tells that how a minority community can actually preserve their language, culture or script. So definitely, if you want to preserve your language, then you can do so by establishing an educational institute. And in that educational institute, you can teach your language. And when you will teach your language, then in this way, you can definitely preserve it. So what Article 30 says? So Article 30 says that all the minority communities, all the minority communities have the right to establish their educational institutions. Means they can establish their schools, they can establish their colleges, and they also have the right to administer them. Administer them means they can make rules for the management and governance of the schools and colleges. So this is Article 30. Now friends, Article 30 classifies minorities on the basis of religion or language. Further, minorities are identified at national or state level. So minorities are classified either on religion or on linguistic basis. And similarly, they are identified at national level or state level. So let me give you an example so that you can understand it more clearly. So suppose friends, we know that in India, at all India level, Hindus are in majority. Means people who follow Hindu religion, these people are in majority. And other religions are in minority. So definitely we can say that at national level and on the basis of religion. So first of all, we will see on the basis of religion. So we can say on the basis of religion, at national level, Hindus are in majority. So friends, Section 2, Clause C of National Commission for Minorities Act 1992 notified Muslims, Sikhs, Christians, Buddhists and Parsis as minority communities on October 23, 1993. So on 23rd of October 1993, these communities were declared as minority communities on the basis of religion at national level. Why? Because their population was less at pan-India level. So which are the minorities communities on the basis of religion and at the national level? So they are Muslim, Sikh, Christian, Buddhist and Parsis. And definitely Hindus are in majority in India. So these communities which I told you are the minority communities at the national level. Now friends, according to the Supreme Court of India, the minority on the basis of religion will only be seen at national level. Why? Because according to Supreme Court, religious minorities should only be seen at the national level. They should not be seen at the state level. But friends, linguistic minorities means minority based on language will also be seen on the state level. So I will give you one example so that you can understand it more clearly. So suppose friends, I gave you the example of Uttar Pradesh. So we know that in Uttar Pradesh, Hindi speaking people are in majority. Means people who speak Hindi language, these peoples are in majority. But friends, we know that in Tamil Nadu, people who speak Tamil are in majority, definitely. So these people are in majority. But suppose now in the state of Uttar Pradesh, 500 people lives who actually speak Tamil language. Now we know that the population of Hindi speaking people in Uttar Pradesh is very large. But the population of Tamil speaking people in Uttar Pradesh is very less. So if the population of any particular linguistic minority, if any particular linguistic group is less in any particular state, then that linguistic group will be declared as minority at the state level. And then they will get the right to establish their educational institute and to preserve their language. So for example, in this example I told you that in Uttar Pradesh, the people who speak Hindi are in majority. So definitely the people who speak Tamil are in minority in Uttar Pradesh. So people who speak Tamil are actually a minority community in Uttar Pradesh. So definitely friends, now these people will have right to establish and administer their educational institutions. So let's move further. So friends, then comes Article 30, Clause 1, capital A. Now what is this article? So let's study it. So friends, it was actually not the part of Indian Constitution from the very beginning. It was added by 44th Amendment Act 1978. Okay, so it was added by the Parliament in the Constitution by 44th Amendment Act 1978. Now friends, minority educational institutions enjoy right to property as their fundamental right. So as we all know that right to property is now no more a fundamental right. It has been removed from the list of fundamental right. But according to this article, now also minority educational institutions means the educational institutions which are established by the minority communities. So all the minority educational institutions have right to property as their fundamental right. So currently also minority educational institutions have right to property as their fundamental right. Now friends, though state can take over such properties provided it is in public interest and state has to give due compensation. Now what does it mean? So it means that if government want to take the ownership of such properties, if government want to take over such properties, means properties which are owned by minority educational institutions, then government can do so. But government has to satisfy two conditions. The first condition is that it should be in public interest. Now how it can be in public interest? So suppose I will give you now one example. So suppose friends, in any metro city, suppose in Delhi, a metro line has to be laid, and in between that metro line a educational institution is coming, and that educational institution is actually owned by any minority committee, means that is a minority educational institution. Now definitely, as we all know that metro cannot change its path, so now state has to remove that educational institution from that place. So now it is in public interest. Why? Because it is in the interest of the public of Delhi. Okay, because metro is very important for transportation. So now what state can do? State can take over that property. But friends, the second condition is that state has to give the due compensation. Means government has to give the fine. Means government have to give a good amount of money to the minority community. Or government can also give land at any other place. Okay, so government has to give due compensation. Then only government can take over such property. So friends, then comes Article 32. So what Article 32 says? So Article 32 is right to constitutional remedies. Okay, now what is the meaning of remedies? So remedies means a kind of treatment or a medicine. Okay, so what is Article 32? So Article 32 is right to constitutional remedies. Now friends, it confers the power on Supreme Court to issue appropriate order, direction or writ to enforce fundamental rights if found violated. Now what does it mean? So it means that if government or any other individual has violated the fundamental right of any individual, then Supreme Court has the power to give order to government to give order. Supreme Court has the power to give order, to issue direction to the government or that individual to restore the right of individual whose fundamental right is violated. Okay, so what does it mean? So suppose if government has violated the fundamental right of any person. Okay, so if government has violated the fundamental right of any person, then Supreme Court can review the action of the government, and if Supreme Court find that government has actually violated the fundamental right of that person, then Supreme Court can give order to the government. Okay, and Supreme Court can restore the fundamental right of that person. So this means right to constitutional remedies. Okay, now friends, Article 32 allows the individual to directly approach Supreme Court in case his fundamental right is violated. Now what does it mean? So friends, suppose if any ordinary legal right means right which is given to you by the ordinary law of the land, means law which is passed by parliament or state legislature. So if any ordinary legal right is violated, then person can only file a legal case in the subordinate court. But friends, if the fundamental right of any person is violated, then person can directly file a case in Supreme Court. Okay, then Supreme Court will give relief to that person. So this is the power of fundamental right, and this power to all the fundamental rights is given to them by Article 32. Why? Because actually Article 32 empowers the people to directly approach Supreme Court if their fundamental right is violated. Means Article 32 contains legal remedy for the violation of fundamental right. Now what is remedy? Remedy means medicine, cure or treatment. Means if, suppose friends, if any person has got typhoid, okay, so if any person has got typhoid fever, then where he will go? Definitely he will go to doctor, any physician, and that physician will give him antibiotics. Okay, so what are those antibiotics? So those antibiotics are actually medicine for the fever. They are actually the treatment for that fever. Similarly, Article 32 has the legal remedy for the violation of fundamental right. Means if the fundamental right of any person is violated, then that person can directly approach to Supreme Court, and then Supreme Court will restore the fundamental right of that person. Then Supreme Court will give relief to that person. Means Article 32 actually contains the medicine for the violation of fundamental rights. Therefore, it is Article 32 which makes other fundamental rights real and enforceable. Okay, so what does it mean? It means that actually Article 32 gives power to all other fundamental rights. Actually, Article 32 makes all other rights enforceable, because if there is no Article 32, then how Supreme Court will be able to protect you? Then how you will be able to directly approach Supreme Court? Means if there is no Article 32, then government can easily exploit you. Then government can easily violate other fundamental rights. But it is Article 32 which gives extraordinary powers to all other fundamental rights. It is Article 32 which makes all other fundamental rights enforceable. Means if government will violate your fundamental rights, then you can directly file a case against the government in the Supreme Court of India. It means that Article 32 provides teeth to fundamental rights, to other fundamental rights to bite. Okay, means Article 32 provides teeth to other fundamental rights to bite. Means Article 32 actually provides them power to act. Without Article 32, they are not useful. They become useful only with Article 32, because they are like the teeth of Article 32. Means if anybody tries to violate any fundamental right, then you can bite him. How you will bite him? You will definitely bite him by filing a case against him in the Supreme Court of India. Means actually by punishing him. So Article 32 is very important fundamental right. And that's why, friend, we can say that Article 32 is very essential for the functioning of healthy democracy. Means if you want that democracy should function correctly, government should not take away the rights of the people, then Article 32 is very important for that. So friends, this was the reason why Dr. Bhimrao Ambedkar described Article 32 as the heart and soul of the Constitution. Okay, so according to Dr. B.R. Ambedkar, Article 32 is the heart and soul of the Constitution. Heart and soul means it is the most important article given in the Constitution of India. It is just like the spirit. It is just like the soul of Indian Constitution. It is it is the most important article of Indian Constitution. Now friends, what is Article 32 Clause 2? So Article 32 Clause 2, it is writ jurisdiction of Supreme Court. Okay, so it is writ jurisdiction of Supreme Court. Now what is the meaning of writ? So writ means any customized order. Now what is customized order? Customized order means an order with some special effect. Okay, so writ means writ is a kind of order given by Supreme Court. Okay, so writ means a order with some special effect. Okay, now friends, we will study about the type of writs and everything about writ in the next class. Okay, for the time being, you just understand that writ means a order with some special effect. Now this concept was adopted from England. Okay, so actually we adopted this concept from England. In Indian Constitution, writ jurisdiction is enjoyed by Supreme Court under Article 32 and High Court under Article 226. Now what does it mean? It means that Article 32 actually provides the power to issue writ to Supreme Court, and Article 226 provides power to issue writ to High Courts. Now friends, writ jurisdiction allows the court to issue appropriate writ for the enforcement of right of the individual. Now what does it mean? It means that if the fundamental right of any person is violated, then Supreme Court or High Court can issue particular writ and they can restore the fundamental right of that person and they can enforce the fundamental right of that person. Now friends, writ jurisdiction also implicitly confers the power of judicial review to High Court and Supreme Court. Now what does it mean? So I will give you one example so that you can understand it very clearly. So suppose friends, if there is a person and the name of that person is Pappu. Now what happened that police has arrested the Pappu arbitrarily. Okay, arbitrarily means police has not followed the constitution while arresting the Pappu. For example, police has not followed the provisions given in Article 22, Article 21. For example, when police arrested Pappu, police didn't tell the ground that on what grounds we are arresting you. Even police didn't have any proof when police arrested him. And after arresting the Pappu, police didn't recorded it in the official police diary. Moreover, police didn't present him before the magistrate. Okay, means police arbitrarily arrested the Pappu. Now friends, what is Article 21? So Article 21 says, means no person shall be deprived of his life or personal liberty except according to the procedure established by the law. Okay, so according to Article 21, Pappu also should not be deprived of his personal liberty. And if police want to deprive Pappu of his personal liberty, then police can do so only according to the procedure established by the law. But actually when police arrested Pappu, police didn't follow the procedure established by law. Why? Because according to law, actually police has to follow Article 22 while arresting Pappu, but police didn't follow it. So it means that Pappu was illegally arrested by the police, or we can say that police actually kidnapped the Pappu. Okay, so police illegally arrested the Pappu. And now policemen are also not telling that we have actually arrested the Pappu. So now what the family members of Pappu can do? So actually Article 21 is the fundamental right of Pappu, which provides him the right to his personal liberty, means nobody can arrest him like this. Nobody can kidnap him like this. He has the right to his liberty. So now what happened that the father of Pappu, okay, so the father of Pappu filed a case against police in the Supreme Court of India. And then what Supreme Court ordered? Then Supreme Court, okay, so when the father of Pappu filed a case against police in the Supreme Court of India, then first of all, what Supreme Court will do? So first of all, Supreme Court has to decide that whether police has arrested Pappu or not, and then whether police has arrested Pappu correctly or not. Okay, so it means that Supreme Court has to review the action of police. Okay, so it means that Supreme Court has to review the action of police, means whether this particular action of police is correct or not, whether police has done it correctly or not. So whether this particular action of police is correct or not. So what Supreme Court has to do? Supreme Court has to actually review the action of police. And for reviewing the action of police, what Supreme Court will do? Supreme Court will either apply procedure established by the law or due process of the law. And I have told you in the beginning of the lecture that they are the methods of judicial review. So what actually court will do? Court will do judicial review of the action of the police. Okay, so here we can conclude that writ jurisdiction actually indirectly provides the power of judicial review to Supreme Court and High Court. Why? Because actually before issuing the writ, court has to do the review of the action of legislature or executive. So now what court will do? Court will definitely review the action of the police. Now friends, suppose when court reviewed the action of police, then court found that police has done wrong. Police has also committed this thing illegally. Why? Because police has not followed Article 22 while arresting the Pappu. Police has not told the ground of arrest to Pappu while arresting him. Okay, police has not presented the Pappu before the magistrate and many things. So Supreme Court found that the action of police is wrong. So now what Supreme Court will do? Supreme Court will issue the writ. Okay, so what Supreme Court will say? Supreme Court will say that release the Pappu. Okay, so writ means, what is writ? Writ is a kind of writ is a order with some special effect. So what Supreme Court will do? Supreme Court will say that present Pappu before me, and then Supreme Court will release the Pappu. So this is a kind of order. So what is writ? Writ is a kind of customized order, means a order with special effect. But before issuing writ, what Supreme Court has to do? Supreme Court has to review the action of legislature or executive. Means writ jurisdiction indirectly provides the power of judicial review to High Court and Supreme Court. Now friends, Supreme Court has expanded the scope of writ jurisdiction by starting the concept of public interest litigation. Now friends, what is PIL or public interest litigation? So PIL or public interest litigation is a separate topic, so we will study about it later. So here I will give you only a little idea about it so that you can understand. Now friends, what happens in, for example friends, what is a general practice? So anybody can file a case in court if that person is indirectly or directly affected by the case. Okay, so a person is allowed to file a case in court if that person is directly or indirectly affected by that incident or by that case. But under public interest litigation, even people who are not directly involved in the case may bring the matters of public interest to the court. Okay, so people who are even not directly involved in the case may bring matter of public interest to the court. Okay, and it is the court's privilege to entertain the application for the PIL. Okay, so what happens in PIL? That people who are even not directly involved in the case, they can also bring the case to the court, but that case should be of public interest. Okay, so they can also bring the matters of public interest to the court. So this is PIL, public interest litigation. Now don't worry, this is a separate topic, so we will discuss about it later on. Okay, for the time being you just understand this. Okay, so friends, Supreme Court has expanded the scope of writ jurisdiction and started the concept of public interest litigation. Now what is Article 32 Clause 3? Now friends, under Article 32 Clause 3, Parliament has the power to confer writ jurisdiction by the means of law on any other body. Now what does it mean? So it means that we know that High Courts and Supreme Court already has the power to issue writ. But friends, Article 32 Clause 3 says that Parliament can make a law, and by making a law, Parliament can provide the power to issue writ to any other body also other than High Court or Supreme Court. And using this power, Parliament has enacted various laws and gave the power on number of tribunals like CAT, SAT, JET, NGT. Okay, means Parliament has enacted many laws, and Parliament has given the power to issue writ to many bodies like CAT. What is CAT? Central Administrative Tribunal. What is SAT? It is State Administrative Tribunal. What is JAT? It is Joint Administrative Tribunal. What is NGT? It is National Green Tribunal. Okay, so definitely we will discuss about tribunals later on because this is also a topic. Okay, for the time being you just understand that Parliament has enacted various laws, and by enacting the laws, Parliament has given the power to number of tribunals to issue writ. Now friends, let's talk about the suspension of fundamental rights. So what Article 358 says? So according to Article 358, when national emergency is external emergency, Okay, so when national emergency is external emergency, that is due to war or external aggression, then fundamental rights under Article 19 stand suspended automatically. Now, what does it mean? So, friends, actually, national emergency can be of two type: internal national emergency or external national emergency. Now, this external national emergency can be on two grounds. Okay, it can also be of two type. For example, war or external emergency due to external aggression. Okay, so Article 358 says that if there is external national emergency in the country, then the rights which are guaranteed under Article 19, these rights will automatically be suspended. Means now these rights are no more with the citizens until emergency is not over. Okay, so what Article 358 says, that if there is national emergency and that national emergency is on external ground, means that national emergency is external emergency, means it is due to war or external aggression, then the rights which are guaranteed under Article 19, they will automatically suspended. Means there is no need to suspend them by a different proclamation, by a separate proclamation. Automatically these rights will be suspended. Means now citizens will not enjoy these rights. Okay, now friends, what is Article 359? So Article 359 says that if national emergency is internal or external, then President by a separate proclamation can suspend the enforcement of one or more fundamental rights except the fundamental rights under Article 20 and 21. Now what does it mean? So it means that under Article 359, whether the national emergency is internal emergency or it is external emergency, President has the power, that President can announce. What President can do, President by a separate proclamation, he can suspend the enforcement of one or more fundamental right. Okay, so President can suspend the enforcement of any fundamental right if there is a national emergency. Okay, so whether the national emergency is internal emergency or the national emergency is external emergency, in both the conditions, President of India has the power to suspend the enforcement of any fundamental right. Okay, but President cannot suspend the enforcement of fundamental rights under Article 20 and 21. And actually it was added by 44th Amendment Act. So by 44th Amendment Act, it was added that Article 20 and 21 will never be suspended. Okay, so they are never suspended. Now friends, there is one thing to pay attention on, and that is that Article 358 provides for automatic suspension. Means Union Council of Minister and the President do not enjoy discretionary power regarding suspension of freedom under Article 19. Means they will be suspended automatically. President do not have the discretionary power. Okay, but in Article 359 gives discretion to Union Council of Minister and President to suspend and restore any fundamental right as per the demand of the situation, except fundamental rights under Article 20 and 21. Means Article 359 gives discretionary powers to President and Union Council of Minister, that according to the demand of time, they can suspend and they can restore any fundamental right. So that is their discretionary power. Now friends, with this, your topic of fundamental rights is now completed. Okay, so your topic of fundamental rights is now over. So in the next class, we will continue our discussion with the types of writs. Okay, and now the fundamental rights is over. So friends, I have uploaded the link of notes in the description of the video, and you can also download the notes from my blog. Okay, you can also follow me on Instagram. Okay, my Instagram ID is Prashant IAS7. So friends, I hope that you all have enjoyed the lecture, and if you have enjoyed the lecture, so please like the video, comment, subscribe to my channel, press the bell icon, and share this channel to as many people as you know who are preparing for UPSC or any state PSC. Till then, take care of yourself. Thank you.